the Senate Insurance Labor Committee has arrived, so we are going to try to start on time today. I'm sure we have a few other committee members that are on their way over, but we're going to get started. Probably going to have a full discussion today. So I want to ask Senator Harbison to please open us in a word of prayer, if you would. And what's your mic number, you think? 11?
Sir.
Thank you.
All right, thank you. If you bow with me, Father God, we thank you for the blessings of this day. Let us use it wisely and be mindful of everybody's feeling, but at the same time, keep a godly view on things that we prepare for the consumption of our constituents. These things we ask in Jesus' name. Amen.
Thank you. Thank you for that good word, Dean. So we have two bills today. We're going to hear Senate Bill 35, which I'm the primary sponsor of, and Senate Bill 39, which Chairman Tillery is the primary sponsor of. There is a sign-up sheet available if anybody wants to make a comment. You need to sign up, and we're going to take those up in about 5 minutes. I'm glad our Secretary of the Committee has arrived. And Madam Secretary, the first bill that I want to hear is, I'm the primary sponsor, Senate Bill 35. Would you mind swapping places with me and let me present my bill?
Okay, Senator, the floor is all yours.
Thank you, Chairman, and thank you, Committee. As most of you, I think, know, I'm an insurance agent as my primary profession. This being a part-time job as a state senator. I've been in the insurance industry for 29 years, and we're an independent insurance agency representing a lot of different carriers, and we sell a lot of home and auto insurance as well as business insurance. And what we have seen in the last probably really 4 years or so, really probably since Hurricane Michael, is a more prevalence of insurance companies deciding to non-renew individuals' homeowners' insurance policies. And the current statute requires the insurance company to give the policyholder 30 days written notice through the U.S. Postal Service, 30 days written notice, however they want to deliver it, but it's primarily the U.S. Postal Service, of the non-renewal decision. In the market that we are in, it's a hard market, and with the delay of time it often takes to get mail, we are seeing customers that aren't being notified, really aren't receiving the notice maybe only a week before their expiration of their policy, and they realize, hey, I don't have an offer from this carrier to renew, so I'm in a mess. So this is a consumer protection measure to change that notice requirement for this only applies to property that is somebody's residence. And it will change it from 30 days to 60 days. I have talked to the industry representatives that are working here at the Capitol, and I haven't received any major pushback from them. The carriers, I think, understand the need for this and seem to be amenable to doing it. I want you to notice that there is the original bill that I dropped had an effective date, or really was silent on the effective date, which means it would have, if the governor signed it, it would have gone into effect July 1 of 2025. And the only feedback really that I received from the industry was we need a little time to get our systems updated and get the processes in place. Would you mind to give us till January 1 of 26. So I wanted you to see the original bill, which is LC 460947, and then I wanted you to see the committee substitute that I brought, which is LC 41059S, and you'll 461059S is the committee sub, and you'll see that in section 2, it gives the effective date will be January 1 of 2026 if this were to pass. So the only change in the code is going to be on line 14, changing it from 30 days to 60 days. And then line 23, which is the effective date. I'll be happy to answer any questions if there are any.
A couple questions. I've a question, which is there any consideration for other ways of delivery, like email, for example, or is it always done by U.S. mail?
So I have been asked that question before, so I have given that a little thought. Generally, the agents, like Senator Harbin and our agents, and Senator Harbison is the agent, we generally do get email notification at our office. But we're seeing such a prevalence of this that it's pretty hard for us to keep up with it. The problem with the reason it has to be written notice, I think, and I think it's a valid reason, is people's email addresses change. Not all of our insureds have email addresses. I don't think that's a real reliable way. You know, it could go to their spam. So I just don't think that's a reliable way to do it. Now, if a carrier wanted to do email and written, that would be fine for them to do that. And the agents are generally being notified both in writing and via electronically, either downloaded into their system or email. But and I wish Senator Harbin would maybe just chime in, but it's been pretty overwhelming trying to manage this.
Did you want to
With
say
such a
anything? Because there are
tight-
several questions.
Okay. Well, since Chairman Walker asked me to step in, I think that we have to understand that most of our insurance law is all dictated on the U.S. mails, and that's been how most of the contract law, all of that is set up. We are seeing delays in mails. That presents a problem. I think this is a very reasonable bill, very foresight, a lot of foresight as far as what's going on. I had one yesterday, same thing. Notification had been sent but had not been received yet. We had got notice of it. We called the insured. They didn't know anything about it from that standpoint. So I think your bill of extending at least the days gives that. And as we see the insurance markets be more tight and more strict, even the agent has to have more time in order to be able to place the coverage, or the insured has to have enough time to be able to find a market for it. So I think it's a good piece of legislation consumer-wise. It makes sense and also helps the consumer and the agent. So good work, sir.
Thank you. Senator Merritt, you pushed your button first.
Thank you, Chairwoman. Mr. Chairman, a couple of clarifying questions. Did this bill include any penalties for insurers who fail to provide the extended 60-day notice? Because that's not specified in the legislation.
The insurance commissioner has authority to enforce this already in other sections of the code. Okay. So he could do a market conduct violation, or so he has the authority to enforce this.
All right, and he knows. I guess he knows to do that, because I guess my concern is not explicitly implied here, but he knows that is possible, or he should be enforcing that.
Yes, and I've worked with their office on this too. But
okay,
yeah, they routinely have to enforce all types of insurance law and if they also get a lot, consumer complaints, and they run that down, and agents will call in and complain. So he's engaged in this process for sure.
Okay, and my second question, could insurers circumvent this requirement by increasing premiums or reducing coverage options rather than issuing the formal renewals?
Well, they can, I don't know that I wouldn't describe that as circumventing the non-renewal notice requirement, but they have many tools at their disposal and levers they can use if they, so the insurance commissioner has to approve any rate increases that they have to file their rates with the insurance commissioner, and he has to approve the rates. And they can't decide just to, we want to increase Senator Merritt's rates. It's an across the board situation based on like risk. But they can decide that we're not going to write any policies any longer with a $500 deductible. We're going to require a minimum of a $1,000 deductible going forward, that kind of thing. But all that is regulated by the insurance commissioner and is part of their rate filing. And there may be somebody in the audience from the commissioner's office that might want to add to that if you have further questions on what their regulatory authority is and how they use it. But yes, it's a free market, and it is a contract between the carrier and the policyholder, and it's, you know, it's contract law, and I'm for free market. I just think in the current situation we find ourselves, I think giving the consumer more time to respond and react and find replacement coverage, or either try to remedy the problem with the carrier and get the non-renewal rescinded, is better for the consumer.
Senator Robertson?
Thank you, Madam Chair. Chairman, the bill's to change it from 30 days to 60 days. Is that correct?
Yes, sir.
Okay, I just want to make sure I wasn't losing anything in the interpretation here. Currently, are these notifications sent registered mail?
No, sir.
Okay, so with the dysfunction that we have in the United States Postal Service, do we think 60 days is enough? And I say that because I'm sure some of y'all are still getting Christmas cards from me.
That's
Yeah, I just
I mean, that's a valid point. It's certainly an improvement over our current situation, and as Senator Harbin alluded to, and I've mentioned also, it also gives the agent more time. The agent's likely to, I mean, we're going to know about this prior to the policyholder most times, and even 30 days for us, even if we knew, you know, and had the full 30 days, with the volume of non-renewals and the activity in the hard market, it's really put a lot of strain on the agents too to remarket this for them. So I'm comfortable with 60 days
All right,
to
thank
answer
you,
your
sir.
question.
Thank you.
Senator Hodges, did you have a question?
Thank you, Madam Chair. Mr. Chairman, I was going to ask the same question that Senator Robertson asked, but I'll ask it this way. In your 29 years of experience, and Senator Harbison could chime in on this too, but in your 29 years of experience, is 60 days enough time to shop and get replacement insurance? I mean, when you figure the problems we've had with the U.S. mail, and to go from 30 to 60 days, I mean, I've seen again, I'm getting Christmas cards now, but an additional 30 days, does that give the person whose insurance is being revoked time to shop and replace it?
I feel like it does. I mean, I would, you know, I would entertain it if somebody wants to change it to 75 or something. But I think
Right.
60's. I feel like 60's enough. I think it's doubling what we have now, and I think
Yeah.
it's balanced. It's fair to the insurance companies. We don't want to. We want to be a friendly business environment for the insurance companies too. I mean, we don't want them exiting the market altogether. So I think in my discussions with the industry and other agents, I feel very comfortable on 60 days.
Well, I know that I'm from the coast, obviously, and in some coastal areas of other states, you know, we've had carriers leave the coastal area. And, I'm beginning to see a little bit of that, you know, in our state on the coast. And I was just wondering, I'm more concerned about if carriers are getting out of a particular area, then, that there's lesser number of carriers to go replace your coverage with. I just want to make sure that people have enough time to do that.
Yes,
That's all.
sir. Well, thank you for the question. Just for education of the committee and the audience, and I'll ask again for some help from other folks smarter than me in the room, but we do have a Georgia Underwriting Association plan, which is the insurance of last resort for homeowners. So we try not to go there if we don't have to. Generally, it's much more expensive, but there is an state-backed alternative program for the homeowner that can't find coverage anywhere else, and you're supposed to exhaust all the voluntary markets before you place a client in that program. Is that
Okay, I think that's all the questions that I see. And nobody signed up to testify on this. Senator Robertson, you had another question?
No, ma'am, when the time is right.
Okay, I think it's the appropriate time.
Motion do pass.
Is there a second?
Second.
Okay. Any further discussion from the committee? Okay, all in favor, raise your hand. Any opposed? Okay, your bill passes. Thank you very much.
Thank you. All right, next we're going to hear from Chairman Tillery. He's bringing us Senate Bill 39. Welcome, Chairman Tillery.
Thank you, Mr. Chairman. Senate Bill 39 dovetails and tags on to Senate Bill 140 that we passed last year. You know that last year was Senate Bill 140. The state, or we as a legislature, banned transgender surgeries for children, for minors, those under the age of 18. As we were going through the budget and budget processing, you know we were a little surprised to see that we're still paying for some of those things. Now, some of them are folks over 18. We didn't ban any surgeries for adults. But I do think that it's in line with what we were looking at last year of banning those under 18, that we were a little surprised to see that our state health benefit plan dollars and state dollars we're still going to support this practice, even on children under the age of 18. Under the age of 18, how would you support it? Well, you would support it by paying for that out of state. So not only is it then a process that we have already acted under Senate Bill 140 to say we did not think should happen, but it's a process that we're still paying for with state taxpayer dollars, and not just paying for it with state taxpayer dollars, we're then paying for it with state taxpayer dollars outside of our state, because you could not have the surgery here by Senate Bill 140 that we already passed. So Senate Bill 39 seeks to rectify that. It says in simple terms that we will not spend state dollars, state tax dollars, on transgender surgeries and those things that we banned in Senate Bill 140. It goes slightly further to say, hey, state hospitals, so not just state health benefit plans, state hospitals, doctors that are employed by the state, social service dollars that we implement and spend on our needy, that those won't be spent on this procedure, on these procedures either. In case that was not clear, because I would have thought it would have been clear through Senate Bill 140 what the legislature thought was appropriate, we went in Section 4 and reiterated it again, said in no uncertain terms, no state funds shall be expended for health care benefit coverage that includes the gender-affirming care, the transgender surgery care that was provided for in Code Section 4518.4. I'm sure there'll be plenty of questions. I'm happy to answer them. There is one amendment that I would suggest to the committee. In Section 5, you'll see the effective date is the signature of the governor. Because of contracts that we're already in on the state health benefit plan, it's been suggested that for legal purposes, we would be better served to make that be effective upon January 1, 2026. And there's some language that goes to that I was already given by legislative counsel. Happy to read that to you now, Mr. Chairman, if you want.
Yes, sir, read that proposed amendment to us.
The suggestion would be to go in at lines 117 and line 18 in section 5, where it says this act shall become effective upon signature of the governor. And to change that out to say, this act shall become effective upon January 1, 2026, and shall apply to all state health benefit plans issued, delivered, issued for delivery, or renewed in this state on or after such date. Again, I don't think there's really any ambiguity in what the bill does. We can debate if you like that practice or not. But what this bill says is we are not going to spend state taxpayer dollars on transgender surgeries in our state.
Okay, thank you. We have some questions from the committee. So Senator Merritt, I saw your light first.
I have 3 questions, and I do think the senator can answer them pretty quickly because I know how efficient he is. So first question is, how does this bill specifically define gender-affirming care and hormone therapy? I do see that term in the bill. And could this definition lead to unintended denials of necessary medical treatments such as IVF, hormone replacement therapy for menopause, or fertility treatments that also involve hormone therapy?
Thank you for your question, and thank you for helping me clarify. The answer is I do not think it could do that, and I'll walk through why. Gender-affirming care is defined on lines 44 through 46. Hormone therapy is defined on lines 47 through 59. And your question about IVF, nothing in this bill addresses IVF. I don't, not trying to be funny here, I don't know that there's a procedure where someone would go through transgender surgery for IVF. I would not be aware of such a thing.
Well, Senator, sometimes they have to go through a hormone treatment for IVF. Maybe
Right.
not the gender affirming part, but I guess I'm concerned about unintended language in here that could prevent IVF treatments.
Well, in your gender-affirming care definition, it says that gender-affirming care means health care, such as hormone therapy or sex reassignment surgery. I don't think that would relate to pregnancy. Or an attempt to affirm one's individual perception of such individual sex that is inconsistent with such individual's sex. So again, I don't think that would tie into IVF.
All right, okay. We're not gonna do the back and forth.
Right there, Chair.
Okay, I'll come back to you. All right, Senator Lucas.
Senator, are we getting ahead of ourselves? There's a court case going on right now in Warner Robins about paying for the services that this particular person had. And have the courts even said whether or not you can do it?
Whether have the court said
Yeah,
what we could do.
there's a court case in Warner Robins going on right now.
Okay.
And the question I'm asking, are we getting ahead of ourselves? We doing it, and then the court said you're gonna have to do it.
Thank you for the question. I do not think we're getting ahead of ourselves. Remember that it's our proper duty to write the law, and then it's the court's duty to interpret that law. They can only interpret the laws that we write. So, Senator, my answer to that is due to separation of powers, this is our duty.
Chairman Tillery, I have a question. Your bill, I think, addresses the state health benefit plan, state-run hospitals,
Yes, sir.
and state resources, not county government resources. Is that right?
That is correct, Senator. Our duty is state general funds. County commissioners' duties are county funds. So if you look through and you see in section 4, getting to lines 107, it says quite clearly, we are dealing only with state general funds, those funds that we are entrusted by the folks we're elected back home to represent. And it does not in any way prohibit if a county wants to go purchase a separate coverage plan, they can do so. If another local government entity wants to do that, that's fine as well. And if a non-state health benefit plan covers these procedures, this does not in any way eliminate that coverage. It simply says that in Georgia, our state taxpayer dollars are not going to go for that cost.
Thank you for that clarification. Okay, I'm gonna do Senator Harbin, then I'm gonna do Senator Merritt again, then I'll do Senator Robertson.
Thank you, Senator Tillery. What I see here is this is a state issue. If someone did not like the state plan, they have the ability to leave the state plan and buy a private plan somewhere else if they want to. It's only those people who are covered under this state plan that this applies to. Am I correct?
It only applies to the state health benefit plan and state dollars.
Okay.
So state dollars that would be spent at state hospitals, state dollars that would be spent on state social services.
But someone who could leave the plan if they wanted to and go out and find another plan, and it may or may not cover something like that. It is just, this is applying to our state plan only, as I see it. But that person could leave this plan and go somewhere else if they can find it. They have the right to do that.
They do. Now, I'm not going to try to hide behind the wall and pretend like that would be an easy
Right.
task.
Understood.
I'm not. But when you're a state employee, your health benefit plan is paid by state taxpayer dollars.
Absolutely.
And I think we have a duty to our citizens and the citizens of Georgia that if they have overwhelmingly elected us and we've made a position and a policy that we believe shouldn't be covered by state taxpayer dollars that I believe is firmly supported by them, then this is just a further carry on of Senate Bill 140 and Senate Bill Senate Bill 39 here now.
Thank you. Appreciate it.
All right, we're gonna call on Chairman Robertson.
I'm sure it's because I'm her elder, because I'm older. Chairman Tillery, I think both you and I have very much so in our politics and everything else shown our support for helping people who want to have children through fertility treatments and other things, foster care, adoption, and all the other processes. So Senator Merritt's question early on when discussing those issues, and you referenced line 47 through 49 as a definition of hormone therapy, which is also referenced at the bottom of the Senate Office of Policy and Legislative Actions summary. Would you agree that that definition there between 47 and 49 clearly states that it does not involve certain fertility procedures that were mentioned earlier?
Yes, sir, I would.
Okay, I just want to be clear. Thank you.
All right. Senator Merritt.
Thank you, Mr. Chairman. I will try not to go back and forth. Okay, so given that the Affordable Care Act prohibits discrimination in healthcare based on sex, is there any concern with how this legislation violates federal law under the Equal Protection Clause?
No, ma'am. No more than I would think the Equal Protection Clause would be violated if a woman's policy didn't cover a vasectomy. No, ma'am.
Okay. Last question.
Wait, now you gotta. Okay.
One more question, please. And I'm okay. My last question is, what impact would this bill have on individuals who are already or who've already begun gender affirming treatments under state funded plans? What happens to them?
Again, so right now, the open enrollment will open up at the end of the year. So if they're covered right now under a state health benefit plan, I think we're under a contractual obligation, and there's nothing I can do in state law that would change that contractual obligation at this time, from what I understand, based on legislative counsel and legal counsel. So open enrollment will open again. If they wish to choose a different plan that did cover that, they have the ability to do so. But we're giving plenty of notice, us now still just barely being in February, that the state health benefit plan is not going to cover such coverage on January 1 of 2026, as soon as our contractual rights to be able to ban that are reopened and allow us to do so.
Chairman Kilpatrick.
Yeah, I just have a question about the hospital and physician piece of it, because we have nonprofit hospitals, which I usually put quotes around when I speak about it, that do get some tax benefits and so on from that status, and they employ a lot of physicians, and so I'm just wondering if they would be impacted by this at all.
So you're really looking at lines 102 through 106, roughly? Well, let's parse them out and read them together. No healthcare facility owned or operated by the state. So I don't think that those private hospitals or public hospitals would be owned or operated by the state. Nor do I think that, and then it goes on further and says, no physician or other healthcare provider employed by a state agency. If they were employed by the state agency, say like through the public health, for instance, I do think those physicians would not be able to perform these surgeries. But then again, that is our state taxpayer dollars that would be going towards those surgeries if we allowed that.
And follow up, Mr. Chair,
Yes.
quickly. So the federally qualified health centers, that's all federal dollars, so they wouldn't be impacted?
The federally qualified health dollars would be paid mostly through Medicaid funds. So if we need to address that, I'm happy to talk to you about that more. Also, I'm not aware that those procedures are performed at federally qualified health centers. Gotcha.
Okay, who's 11? Okay, yes, sir.
Thank you, Mr. Chairman. Mr. Chairman, I just want to sort of give you my take on my vote. I believe you understand that I voted against 140 last time around. And I want to be very clear that you were very clear. You came to me and I signed on. And the reason I signed on because I was under the impression that it was the Title IX type activity that was being dealt with in this particular bill, and that was I misconstrued that on my part, not yours. You were very clear, and I just simply misapplied it. I just want to explain that you openly and let you know that you were very fair and you were clear about it was on it was my bag, so to speak. All right, just want to be clear about it. Thank you.
Yes, sir. Thank you.
All right, that appears to be all the committee questions at the moment. We do have a sign-up sheet. We've got 12 people signed up. So we have, I think we have 11 signed up in opposition to Senate Bill 39 and 1 to speak in favor of Senate Bill 39. We're on a tight time frame. I've got a hard stop at 4 o'clock. So I would appreciate the folks that have signed up to speak in opposition to either let one or two or three or four people speak on your behalf, or either please do not repeat what the person ahead of you or somebody prior to you has said in the interest of time. Also, we're going to have to limit the remarks to 1 minute per person. So I will start with Amanda K. Seals, Advocates for Trans Equality.
Good afternoon, Mr. Chairman. Good afternoon, rest of the committee. My name is Amanda K. Seals. I'm a partner at the law firm of Bondurant, Mixon, and Elmore, and I'm proud to have represented the 5 named plaintiffs in Rich versus Georgia. This was a case that removed the previously existing exclusion for gender-affirming health care in the state health benefits plan. I'm here to tell you that if you try to undo the promises made by the state of Georgia in the Rich versus Georgia settlement, the promises made to Georgia's citizens, and more specifically to the state's employees and their families, the state will find itself in court again. Passing this bill does not change what was true when we filed Rich. To Senator Merritt's point, pursuant to Bostock and other United States Supreme Court precedent, the exclusion is as unconstitutional today as it was when we filed the Rich suit in 2022. Even Scarametti, currently before the Supreme Court, won't change that, as that case relates only to care for minors, and despite Chairman Tillery's comments, this bill is broader. It restricts care for adults, not just for minors, and it is not limited only to surgeries. I will remind the body also that surgeries on minors aren't a thing that happens. They're not a thing that happens in this state. And I would invite any member of this committee or any member of the body to produce evidence to the contrary. Second, the attack.
Thank you, Mrs. Seals. Thank you. Mr. Benici, UGA Research Assistant. Are you speaking on the behalf of the University of Georgia or
I'm
just,
speaking on behalf of myself.
okay, just wanted to
I'm
be
not-
clear.
This is not a state-sponsored political activity.
Thank
Good
you.
afternoon, Chairman Walker and members of the Insurance Waiver Committee. My name is Drew Benecki, and I'm from Marietta. I'm a UGA Stats and Finance alum and a current UGA student there in PhD, Research in AI Systems. I'm speaking against this bill because I'm a recipient of hormone therapy, and it has significantly improved my well-being. Gender dysphoria is a medical condition and not an ideology. It can't be prayed away or be treated by talk therapy alone. The rise in diagnosis represents a better reflection of the true portion of people who would seek these services in a society free of discrimination. The human consequences of not receiving gender-affirming care significantly outweigh any cost savings. A statistical analysis conducted in 2014 found that the net cost of covering gender-affirming care amounted to 1.6 cents per month. Gender-affirming hormone therapy has been shown to improve patient mental health outcomes for all ages. Gender-affirming surgeries, even cosmetic ones such as facial surgeries, have been shown to cause significant lasting improvements in patient well-being. The financial benefits from improved well-being result in a net positive lifetime return on investment. The regret rate for genital surgery is around 1%, while the knee replacement regret rate is closer to 13%. Yet there's little hand-wringing about that. State health insurance plan even covers chiropractic services, which have little merit in evidence-based medicine. Furthermore, this bill hurts transjordans who receive medical services at public hospitals. Patients wouldn't be able to access their hormone therapy, resulting in significant mental and physical side effects. This also hurts trans public employees of the state and their dependents. This discourages many highly qualified people from working at state agencies and public universities. Anti-trans legislation as a whole is a source of
Andrew.
greater. Yep.
Thank you very much.
Thank you.
Good job. All right, Dr. Cassie Ackerley. She's a physician, I think, and a parent. And then on deck is Jennifer Carpenter.
I apologize. I thought I was fourth. Good afternoon, everyone. Thank you for the opportunity to speak. My name is Cassie Ackerley. I'm a physician here in Atlanta, and I care for pediatric and adult patients. I want to clarify a couple of things. I think you've been provided some misinformation. So minors are not undergoing gender-affirming surgeries in Georgia at all, as was mentioned. That is not happening. So this bill would be addressing something that is not happening. It also goes well beyond SB 140 because it impacts adult patients who are seeking gender-affirming care. We as medical providers, we spend a lot of time training and learning how to take care of patients. And there are a lot of existing barriers that prevent us from doing that. And it is really an affront to the medical professionals when we have state legislators who don't understand what we do and tell us that we have to provide different care to different patients based on their insurance plan. Think about that for a second. If you had colon cancer and you went to get care, would you want to get different treatment because you had a certain type of insurance? That's obviously overtly discriminatory, and so is this legislation. You know, I think you can trust doctors. You can trust us to make and recommend evidence-based medical decisions based on our experience, based on the existing evidence, and also based on treatment guidelines. Gender-affirming care is evidence-based care. It is. There is plenty of evidence. I'd love to come back and speak longer to share that with you.
Thank
I
you,
think there's a
Dr.
lot of
Ackerley.
misinformation.
Thank you very much.
Please oppose this bill and vote in support of medical professionals. Please do not make our job harder.
Thank you. All right, Jennifer, all right, that's enough of that. Jennifer Carpenter with PFLAG, and then Jeff Graham on deck, and then after that, Dr. Jason Snyder. Go ahead.
Good afternoon, committee members. My name is Jennifer Carpenter. I've been a resident of
Hang
Georgia.
on a second. Ma'am, we're not going to have all that either. Go ahead.
I've been a resident of Georgia for 25 years. I reside in Gwinnett County. I am a PhD student down the street at Georgia State University. I have 2 teens in Gwinnett County Public Schools, one of whom is transgender. I'm very concerned about SB 39 for many reasons. First, I stand in full support of all of our educators here in Georgia, and I feel like this bill will negatively affect the quality of education here in the state, as our educators will certainly begin to leave en masse in the wake of legislation that seeks to limit the control that they and their doctors have over the medical care of their families. Graduation rates went up 18% in Georgia between 2011 to 2024, and we are currently setting all-time records in the state at 85%. SB 39 would certainly cause a return to our early 2000 rates of just over 55%, a risk we cannot afford to take. Our educators and children deserve better. Instead of prioritizing how to support educators and deal with inflation and a housing crisis, our elected officials instead have wasted valuable time and tax dollars to infringe upon the rights of some of our most vulnerable citizens, transgender youth.
Thank you, ma'am.
Gender-affirming care is life-saving care, and I can attest to that personally.
Thank you very much. All right. Is it Jeff Graham, Georgia Equality?
Thank you, Mr. Chair, for the opportunity to speak today. You've already heard that case after case, the state of Georgia, frankly, has been losing when it tries to restrict the rights of transgender Georgians. This goes back to 2010 with the landmark case of Vandy Beth Glenn, who used to work for you all until she was discriminated on the job because of her gender identity. I just want to remind you that there are hundreds of thousands of individuals, an estimated 450,000 individuals that identify as lesbian, gay, bisexual, and transgender here in the state of Georgia. We are taxpayers, we are your families, we are your constituents. Less than 1% of the state of Georgia identifies as transgender, but those 50 to 80,000 individuals deserve access to the same level of quality care as their peers, their family members, and their coworkers. I encourage you to please hear the pleads of parents, hear the pleads of transgender individuals, and hear the warnings of constitutional attorneys. Thank you.
Thank you. Dr. Snyder, Jason Snyder, and then we have Bentley Hudgens.
Mr. Chair, Dr. Schneider is not here.
Okay, good. Thank you. Bentley Hudgens with Human Rights Campaign.
Thank you, Chair. I appreciate the opportunity to speak. My name is Bentley Hudgens. I'm the State Director of the Human Rights Campaign. And I want to echo everything that my colleague said today, that this is life-saving, best practice, routine, well-studied health care. This is health care. But I also want to talk about the economic impact. So the Human Rights Campaign, one of our premier studies is our Corporate Equality Index. In our 2025, despite what you might think, we've had a record number of participants. 675 companies got a 100 score, 72 new companies, 376 Fortune 500, 376 Fortune 500, 162 American Law Magazine 200 law firms, a record 1,449 respondents, and 91% of those offer trans-inclusive plan options. Georgia should offer routine benefits that do not discriminate against their own workers who make this state the place that all of us in this room love so much. If Georgia wants to be a competitive place, we should not discriminate against people, and I ask you to vote no against this bill.
Thank you. Chelsea Thompson with Frontline Policy. And then, Carrie Scott will be next.
Thank you, Chairman, members of the committee. So I just want to say that this bill, it's pretty straightforward. So to go back to what's already been said, to second what Senator Harbin said, his point is that this is not prohibiting anyone's ability to receive and pursue an attempted sex change surgery. This bill is making it clear that state dollars are not going to pay for that surgery. And now SB 140 is still in place, and minors cannot currently legally receive, at least, surgeries in Georgia. And this bill is addressing state dollars being used on those surgeries out of state. So just wanted to bring it back to that. And then this bill is consistent not only with SB 140, but also I would argue with the intent of the legislature as we see in SB 140. Unlike the recent lawsuit that was mentioned, the legislature, I would argue here, is doing their job by making law as opposed to judicial lawmaking. And lastly, to refer back quickly to Senator Merritt, earlier you had a question regarding hormone therapy. I will say that in the bill, I think it's line 48, correct me if I'm wrong, but it says for purposes of sex transition, as opposed to hormone therapy that would be used to help someone that was low on testosterone or estrogen and so forth. So thank you.
Chelsea. All right, Carrie Scott. And Carrie, who are you with, or are you just representing yourself?
I'm representing myself.
Okay,
I want to be
cool.
very clear because my name is Carrie Scott. I am an attorney. I've been a state employee for almost 7 years. As you can see, I'm older than 18. About 2.5 years ago, I realized after a lot of prayer and self-reflection that I needed to transition. It has been a wonderful thing that's happened in my life. Part of the reason that has been such a successful transition is because I had surgery about a year ago. That surgery, it was incredible for my well-being. I was in a lot of pain, and now I'm not in pain. That surgery would have been inaccessible to me if it wasn't covered by my health insurance as a state employee. Those of us who work for the state do so because we care for and want to serve the citizens of Georgia. We don't do it for the money, and it is a slap in the face to reward that service by stripping us of the health care access that we desperately need. Access to the state health benefit plan is part of our compensation, so making it untenable for us to be a part of it is a cut in our compensation. And frankly, if I had to pay for out of pocket, my salary would be taxpayer dollars that is paying for hormones anyway. So thank you very much.
All right, Kara Hayden, and then Christine Laughlin next after her.
Hello, everybody. Sorry, I lost my voice. I'm a state employee. I've been a state employee for almost a decade now. I'm a transgender woman. I've gone through surgeries. I've had hormone therapy. If you approve this bill, essentially, you're going to take away the care that I need to continue living. I don't produce hormones normally anymore, so not having access to hormone therapy, you would essentially force me into early menopause, having other medical conditions and things like that, or finding employment outside of the state. Honestly, it's, I've been in the state of Georgia for 30 years. I've been a taxpayer during that time, and it's just extremely disappointing that you would strip benefits away, like others have mentioned, for people that need this care to, live their lives.
Thank you. Christine Laughlin, and tell us who you're with, Christine.
I'm the mother of a trans child. I'm not with a group.
Thank you.
And I'm so nervous I can't find the chair. I'm Christine Laughlin. I live in Newton County, Georgia, and I'm the mother of a trans child. She was suicidal before she started her hormone therapy. If you take it away, that might very well happen again. As a mother, how can I not protest taking away something that is saving my child's life? The other point I wanted to make is that line 110 says such service must be entirely without state funds. So while the claim in here is that this is only about state plans, just about every plan has some kind of state support somewhere in it. And so if this were taken literally, it would cover many more insurance policies than just this state plan.
Thank you, Christine. Gracie Gainey with Community Estrella.
Yes, thank you very much for this opportunity. I guess I would be remiss if I didn't just point something out. The previous speaker talked about how this, her child might have killed herself without this life-saving health care. I certainly think that it's definitely a worthwhile investment as far as state funds towards keeping people alive. But towards a broader point, it's not just a matter of people ending their lives in a moment by any different means. If we don't properly fund treatments of dysphoria this way, and the people can't otherwise afford it, it can result in maladaptive coping mechanisms. They might turn to alcohol or cigarettes, or they might start binge eating or even doing harder drugs. And so, I don't know, I would submit that a stitch in time saves 9. It would be better to just fund the treatments for gender dysphoria than fund all these treatments for the terrible health, these bad, the things that they might do to themselves with drugs and alcohol and cigarettes if they aren't treated. Thank you.
Thank you. All right, that's all our public testimony. Chairman Tillery, would you mind coming back and let's hear from you any remarks you want to have, and then we'll see what the will of the committee is and possibly look at amendments.
Mr. Chairman, I don't know if there's anything more I can add. Just to say again, this is about state taxpayer dollars and state employee benefit plans. All this says is that state taxpayer dollars should not be used for these transgender surgeries.
All right, thank you. I think we've had enough discussion. What's the will of the committee? Yes, sir.
Mr. Chairman, do you want to take up the amendment first, or do you need a
I
motion?
need a motion.
Motion, do pass.
All right, I have a motion to pass, Senator Robertson. Have a second from Senator Harbin. Now, further discussion, and are there any amendments, Mr. Chairman?
Mr. Chairman, members of the committee, after conversation with legal counsel, I do believe that section 5, lines 179 and 117 and 118 would need to be amended to read as follows. This act shall become effective on January 1, 2026, comma, and shall apply to all state health benefit plans issued, comma, delivered, comma, issued for delivery, comma, or renewed in this state on or after such date.
All right. For the committee, I apologize, we don't have this in writing. If you need him to repeat it, he can. I think it's pretty clear, but y'all want him to repeat it? All right. So what's the will of the committee on the proposed amendment? Senator Robertson move to amend it.
Move to amend.
Second, Senator Harbin. Anything else, Chairman? Do you want to?
Legislative Council grabbed me and said that they would like to put an amendment on line 8, that all it does, remember lines 1 through 8 do not change anything about the bill itself. They just lay out what the bill does. And Vince from Legislative Council, you might want to state it, just adding 2 words.
Okay, we'll handle that as a potentially second amendment. Let's get action on, so I have a motion and a second on the amendment changing the effective date on line 117. All those in favor of that amendment, please signify by raising your hand. All right, 1, 2, 3, 4, 5, 6. Opposed, like sign. 3 opposed. Okay, so it's that amendment passes. Now we have another amendment
There was
potentially.
a word amendment from Legislative Council, but it's not something that I can speak to.
This was on line 8. Stand up, Vince, if you don't mind, so we can all hear you good.
Line 8, between the middle of the sentence, between the word date and the semicolon, would be to insert and applicability. That's it.
Mr. Chairman, do you want me to state that again for the microphone for those who
Yes,
can't
sir.
hear offline? Legislative Council said that in line 8, again, just sort of the title of the bill, after the word date and before the semicolon, the words and applicability be inserted.
Okay, do I have a motion on that? Senator Robertson moves amended and second. What's the will of the committee on that second amendment? All those in favor, raise your hand. Opposed, like sign. 6-3. Now, on the LC 520647 as amended, I need a motion. Senator Robertson,
So moved, Mr. Chairman.
and I need a second. Senator Harbin. All those in favor, raise your hand. Opposed, like sign. All right, your bill passes, do pass 6-3. Thank you. All right, I'm going to ask that the Ledge Council, Vince, incorporate all the amendments into a new committee substitute so that we can pass it out that way. Thank you. Meeting's adjourned. Thank you.